Hey, Larry. What time we start on the Friday? I'll give you 3 speakers. Partial, like I just didn't realize this, but one to be. The people's voting here, thanks. Wow. Get that, but I sent you lost. What do you think that's not for? He was tired. Then he come back. Here's a new post. Steve, you gonna do the scripture? You're. You ready? We're getting make sure I'm gonna be on Liam. Make sure he's with us. Kenny, have you gotten a link from Ron yet? Well, if he's on there, do you have to see if he's? And we got another 5 minutes to the time that I told him.
Yep, he's here.
Okay.
Hi there.
He's on.
Okay, can you see the screen good? Hear it's good?
I can hear you good, and it's live streaming right now.
Okay, we're going to go ahead and start as we speak. We're going to have a prayer, scriptures, and then.
Hey, Ron, can you hear me?
I just want to make sure that everything is good for you.
Ron,
yes, I can hear you.
Okay, we just are going to have each of you, I guess, as you speak, you pop up on our screen. And Darren here asked KL if he's okay with this live streaming on YouTube. What about you?
No problem.
Okay. Thank you. Okay. Can we see what? I'll wait to. No, sure.
We need to go back to KL, so we're going to start getting looking at it.
To speak, so it triggers the chain.
Yeah. Okay.
Just tell him.
Thanks for coming today, everybody. Appreciate you being here. We're going to start with our scriptures first. Well, he's talking right now. You ready for prayer? Okay, here you go.
Holy Father, thank you for this beautiful day. We're able to gather. I ask that whatever we are doing here, may it glorify you. We operate at your peace. Just thank you for your love and for just help us to see where you're working in our lives. And your great love draws us to your Son, and then the Son draws us back to you. Father, we just pray for all those that are hurting. It says in your word that you're near the brokenhearted, though it may not seem like it when we're in our pain. But your goal is to help us through that pain. Father, also show us where that pain is not. Sometimes the pain is not real. The enemy, he has the ability to give us pain, emotions, thoughts that are not our own. And I ask, Father, that you reveal that, and then we wish your Son in Jesus' name that it be removed, that healing begins, because healing broken spirits, broken hearts. We just thank you, Father, that your mercies are renewed every day. Woke us up today, and we have today. So help us to walk in you. Thank you. Ask you in Jesus' name. Amen.
Amen. Appreciate
you.
Okay, Steve, let's have our morning scriptures.
All right, today is April Fool's Day for the things that want to pay taxes. Anyway, God has you let the souls here absorb your word in the way you intended. Proverbs 15, a soft answer turns away wrath, but a harsh word stirs up anger. The tongue of the wise knowledge rightly, but the mouth of fools pours forth foolishness. The eyes of the Lord are in every place, keeping watch on the evil and the good. A wholesome tongue is a tree of life, but perverseness it breaks the spirit. A fool despises his father's instruction, but he who receives correction is prudent. There is much treasure, but in the revenue of the wicked is trouble. The lips of the wise disperse knowledge, but the heart of the fool does not do so. The sacrifice of the wicked is an abomination to the Lord, but the prayer of the upright is his delight. The way of the wicked is an abomination to the Lord, but he loves him who follows righteousness. Harsh discipline is for him who forsakes the way, and he who hates correction will die. Hell and destruction are before the Lord. So how much more the hearts of the sons of men? The scoffer does not love one who corrects him, nor will he go to the wise. A merry heart makes a cheerful countenance, but by sorrow of heart the spirit is broken. The heart of him who has understanding seeks knowledge, but the mouth of fools feeds on foolishness. All the days of the afflicted are evil, but he who is of a merry heart has a continual feast. Better is a little with the fear than great treasure with trouble. Better is dinner of herbs where love is than a fatted calf with hatred. A wrathful man stirs up strife, but he who is slow to anger allays contention. The way of the lazy man is like a hedge of thorns, but the way of the upright is a highway. A wise son makes a father glad, but a foolish man despises his mother. Folly is joy to him who is destitute of discernment, but a man of understanding walks uprightly. Without counsel, plans go awry, but in the multitude counsel they are established. A man has joy by the answer of his mouth, and a word spoken in due season. How good is it? The way of life winds upward for the wise, that he may turn away from hell below. The Lord will destroy the house of the proud, but he will establish the boundary of the widow. The thoughts of the wicked are an abomination to the Lord, but the words of the pure are pleasant. He who is greedy for gain troubles his own house, but he who hates bribes will live. The heart of the righteous studies how to answer, but the mouth of the wicked pours forth evil. The Lord is far from the wicked, but he hears the prayer of the righteous. The light of the eyes rejoices the heart, and a good report makes the bones healthy. The ear that hears the rebukes of life will abide among the wise. He who disdains instruction despises his own soul, but he who heeds rebuke gets understanding. The fear of the Lord is instruction and wisdom, and before honor is humility. That concludes today's problem.
Thank you, Steve. Okay, I'm going to let Randy introduce. He actually has two fantastic speakers today. I'm so thankful that he is letting us have opportunity to talk to him and ask questions. Okay, Randy, here you go.
Hello, everybody. Okay, so we got two speakers here. One is Ron Adams, who's on the screen now, and I think when KL starts speaking, it'll automatically switch over. Is that right, Ken? Yeah. Okay, and so first is going to be KL, and KL, I'll let him describe in more detail what he does, but he's basically getting us out of the system. And I've gone through the process. My brother-in-law's done it. My wife's doing it now, and several others that we kind of spread the word to. But he has a fantastic system that is very well established in law, and he can tell you all about it. But it's better than everything else out there that I've seen. And so we've been working together about 6 months, 9 months now. No, it's been longer. Anyway. I've known Ron a little bit longer, and we've become pretty good friends with this. He does debt validation and debt remediation, and basically he exposes how he gives you a process that either you can do on your own, or he can help you, or he can do it for you. And that process is to challenge the debts that you think you have, but that aren't really debts, and then how to challenge them on that, and they never respond. And so there's a process in getting it advice out. So when it's his turn, I'll let
Recording in progress.
Kale, go ahead. You got the floor.
All right, thanks, Randy. Yeah, Randy's one of my newer students. I'll give you a little bit of my background. I started studying this at least 20 years ago. My first contact was a guy by the name of Jordan Maxwell, and he sent me the book Cracking the Code and that kind of stuff. But I wanted to learn as much as I could, so I went around the country, whether it was Canada or England, John Harris, Robert Menard. I studied from Winston Shrout, Gordon Hall, Jack Smith, Brandon Alexander, just about anybody I could to try to figure this out, just like, what probably most of you are doing is trying to figure out how this came to be, because I think everyone definitely could tell you that something's wrong with this system. This is not the same system that we were either brought up on or we were taught in school. That, we were taught that we have the Constitution, we have these Bill of Rights and this kind of thing, when it's pretty obviously that's really what's not happening in this country or the world today. So I did as much studying as I could till I could fit all the pieces together, with the help of a couple other gurus, Eric John Phelps, a guy by the name of Rourke, who brought it all together for me. I've been teaching it for over 10 years, been very, very successful, because I teach it through what I call learning trust law, and which is the highest form of law on the planet. And I'm glad you guys kind of started with the prayer, and the group seems to be somewhat religious, because I wanted to show you that, your relationship with your creator is a trust agreement. Okay. Where, let's just, I was brought up Roman Catholic. So, I was brought up, God sent down Jesus to have certain duties and obligation. He died so our sins could be redeemed, so we could have benefits and go to heaven, which is the very definition of what a trust is. Okay, God being the creator, he created all things on earth. I think the proof of that is obviously that we didn't create this stuff. He did for our benefit. Okay, and he sent down Jesus. That's what a trustee would do. Okay, that he had to perform certain duties for our benefit. He had to die so our sins could be redeemed. And that's exactly, again, what a trust relationship is all about. Okay, here, I'll show you that. I have diagrams I usually teach with and that kind of stuff. So I call that the sacred trust. But, what you have to understand is God's law is also called trust law, which is also called natural law. And I'll repeat it, that it's the highest form of law on planet Earth, let alone the universe. And you might not think so, but even the bad guys, the deep state, the courts, whoever you want to point your finger at, believe it or not, they actually follow trust law to the T, because they know they are held accountable by it. And that's really what runs this world, either through treaties. Treaties are another example of trust. Constitutions are trust. Everything is run under trust law. So I teach it to people through a trust law perspective, because if you can understand trust law, then you'll understand more of what's going on. And again, most people can obviously see that something's amiss. Something doesn't add up in the world today. You see politicians that seem to get away with murder, corruption, stealing, whatever it is. And you keep, like me, going, how does that happen? How's that possible in our system of government, supposing our founding fathers set up? So usually I can talk about several issues for, all day long if I wanted to, but I picked basically the subject that currently the reason why things are the way they are. And again, I want you to understand the how and the why all of this happened, is that we're under martial law. Now, you can call it a soft martial law, you can call it military law, but basically military occupied soft martial law was instituted on March 9th, 1933. All right, now let me give you an example. In 1973, Congressional Record report by Frank Church. This is a quote. The United States has been a state of declared national emergency since March 9th, 1933. A majority of people of the United States have lived all their lives under emergency rule. including me. Okay, but we're not told that. We don't understand exactly what that means. I'll explain, what happened on March 9th, 1933 a little bit later. But let's get to military martial law. When a citizen is governed by military power, he is not governed by the soldier's code of military law, but he is said to be governed by martial law, and this law is entirely different than, your normal constitutional law. These are just some of the facts that prove America is under a military venue martial law jurisdiction. Everyone knows what a zip code is and kind of understands through whether it's David Strait or other people that putting a zip code down on an address sometimes can place you or you be volunteering to be under that jurisdiction of the government you like, which is really true. Zip codes are military venues. That's why they were put into place. Okay, is yes, to try to get you to volunteer into their jurisdiction. It's like if most of you, I guess, or whatever, maybe down in Texas, if you walked across the Rio Grande River, you would understand that your constitutional rights aren't enforceable in Mexico. That's because you're in a foreign jurisdiction. Now, what you don't know is that jurisdiction is just not geographical, that you can contract into a different jurisdiction as if you walked across the Rio Grande and you're now standing in Mexico when you're really standing in Texas, which is what I'm trying to tell you is why you might not get those constitutional rights in court that you think you deserve. Okay? Only under military law does Congress have the statutory authority to combine equity, admiralty, maritime law. So in 1938, when they brought in the Federal Rules of Civil Procedures, they merged a lot of the law forms at that time that used to be separate. So they put common law under admiralty, under maritime, called it kind of a Roman civil law, but it's all into one. So if you go into a courtroom and ask for common law, you're actually asking for their statutory military law. Okay, the only other law form on their books today since 1938 is equity. And I'll get into that maybe at another lecture, but there's really two law forms. If you want to go back and understand equity, if you read the Constitution, Article 3, Section 2, Clause 1, it tells you that at that time, two law forms were brought over from England, common law and equity. So most people always hear that and think that common law was the only thing that came over. Well, that's not true. Equity was another law firm that also came over with our founding fathers, and they instituted, and it's part of our Constitution. This is why it's still available even in today's courts. Okay? This is an example. Headline news in the American Juror Society, which is, a judge and law firm magazine, 1996. Quote, judge admits to War Powers Court on the front page, May 7th, 1996, a municipal court judge, Carol Wardell, in a traffic case. Now, the defendant refused to enter the bar unless she removed the flag. Judge Wardell stated that she will not protect his rights under the War Powers Act of March 9th, 1933, and she would not change the flag in her courtroom. So here we finally, normally they will never admit this, but we actually had a judge on a transcript admit that she was under the War Powers Act, which is the one I keep talking about, March 9th, 1933, where that was instituted at that time, and that things are different. And then in their district, state, county courts today, they cannot recognize the Constitution, nor normally will they even let you speak of it. All right? Military government is that which is established by a commander over an occupied enemy territory. The people are generally left unmolested in ordinary domestic and business relationships, which we are. If you notice that they kind of leave us alone to do what we want, but there's all of these new rules that are instituted, like the income tax, all of these codes and statutes. You have to have a permit to build a house. You have to have a permit to do this. You need to have a license to do this type of work. So all of that stuff came in after 1933, all under the military government. Okay, it's a way of controlling you and controlling the money at the same time. under the Constitution, Article 1, Section 8, and the law of necessity, one of the absolute international rights of the states is self-preservation. And I think everyone can understand the law of necessity, which has been for thousands of years, is like the law of self-defense. That normally, in our system, that you can't kill someone that's illegal and even unlawful. But if circumstances exist where you were defending your family or yourself, then it is legal and lawful to kill someone. Okay, so that law of necessity has been used by many countries over the centuries to institute these national emergencies. Okay, and for lack of a better word, suspend the Constitution that is presently there. It's always done under a national emergency. Okay, under this law of necessity, which is 5,000 years old. One of these powers is to institute military government. Under the American Constitution, Admiral Maritime is a civil jurisdiction that can be regulated under a military venue. Admiralty courts are merely civil in nature, not criminal, and portions of the Bill of Rights do not apply in Admiralty courts. And again, I think probably there's enough people on this call to obviously attest to that fact, that they try to go in there and either assert or get the judge to recognize any of their constitutional rights, and you absolutely get none. I think of it more, I've been in the military. Anybody out there that's been in the military would understand this a lot better, that when you voluntarily contract to be on active duty, you volunteer to be in another jurisdiction. It's called Uniform Code of Military Jurisdiction, UCMJ. And you learn very quickly in that system that you're guilty till proven innocent, and that they can charge you, they can punish you with no defense, no rights, no nothing. And that's really what's going on in today's court. Is there's this presumption that anyone is one, an enemy of the state, a rebel, belligerent, and you're guilty, and that somehow you have to prove yourself innocent, which means your chances realistically of beating them are probably in the 1% range. And you got to be smart enough just to even win that. And I think it's more of a fact that they let people win occasionally, because if no one ever won, people would figure out real quick that the whole system is completely different and rigged. But my point is that really, that there's a different jurisdiction, a different set of laws that are going on in a courtroom, let alone out in your everyday lives. Okay. Secondarily, occupants are treated as rebels, belligerents, and enemies of the state. The commander has the right to seize property. Every state of Texas, state of Florida, state of Illinois is a de facto conquered military territory. Again, this is what happened with Proclamation 2039 and 2040 on March 9th, 1933. So under the Constitution, there are three kinds of military jurisdiction. Number one exercised in peace. Well, that's not what's happening really. 2, one in foreign power in the time of rebellion. 3, one in a time of invasion or national emergency. Now, if you go back to March 4th, 1933, when FDR was inaugurated, and again, usually I play this, and there are some podcasts out there where I'm going to go over this kind of thing, where he specifically asked, because of the national emergency, he wanted special powers, executive 2 powers, as if he was at war. And this is where, again, the martial law comes into play. All right. This is one of his quotes. "I want Congress to give me broad executive power as if we were at war." Now, that's the Trading with the Enemy Act, again, of March 9th, 1933. So a victorious army seizes all public money. Wow. So this is really, I hope that I can get you to understand what's going on with your car and your houses and property taxes and just about anything else. Now, they called the emergency, the stock market crash in 29, and then they come around to 33. And basically, they didn't have enough gold to redeem the dollar bills, the $20 bills at that point, because at that point, gold was worth $20 an ounce, and you could take a $20 bill into a bank, and by law, they had to redeem it and give you an ounce of gold. Well, everyone knows that the Federal Reserve Act started in 1913, and in case you haven't read the act, but I have, they charge 6% interest on using Federal Reserve notes. Okay. And at that time, they had to have a 40% collateral backing of gold. So they had to have 40% of what they were printing in the bank as gold, as collateral, in order to legally print that money. So in the act, they charged 6%. And instead of getting paid in Federal Reserve notes, they wrote into the act that they get paid in gold certificates, which was like a piece of paper stating that they had a claim on as much gold. So they didn't even want their own money that they were creating, because they knew that over time that it gets devalued and that sooner or later it is worth nothing. Like you guys will totally understand today that a dollar bill when you were a kid does not buy the same stuff that does today. So you get to 33, there's a shortage of the gold. They call it, FDR gets on whatever on the radio, says everybody's hoarding gold, thus they need to seize the gold, right? But what did they do after they seized it? They turned around and almost doubled the price from $20 to $35. It was really about getting more gold as collateral in order to pay the debt of the federal government. So this is really why all of that happened. All right. Now, here's the real issue. Here's the real issue. When they did that, all publicly registered property was placed in trust. So all land at the time that people had a loyal title to was registered with the government. And when I say the word registered, you got to think it was placed in trust, which meant the farmers now got, or people got equitable title to the land, which is use and possession. This is trust law again. The government maintained legal title to the property because, again, commander in chief has the right to seize that property if needed at wartime. So even, if there really was a World War III today, they could come in and take your house. They could come in and take your land. If you had a farm, they could take control of the crops, all under the law of necessity, as if we were at war. So this is how they did it. They publicly registered all the property, okay, which included all the birth certificates. So it could be used as collateral to print more Federal Reserve notes, or what I call monopoly money, phony money. So since 33, the land that you bought, or the house on the land that you bought, has been in a trust. Okay, so which meant you get possession of the house, you get full use of the house, you can paint the house, you can put a new roof on, you can put new air conditioner in, but because the government has the claim of legal title on that house, they are allowed to charge property taxes. And guess what happens if you don't pay property taxes? They have the legal right to come in, and they don't take the house, they repossess the house. Think of the wording again. On a foreclosure, they're suing for repossession, which means they're trying to get your possession, your equitable title. They already have the legal title. Okay. So this is why, and again, there's been so many people that have had their houses paid off, they stop paying property tax because they don't think they have to. And I'm telling you, you do. Okay. So don't stop paying property taxes until you have a loyal title. But if obviously when they have it, they have a right under the current legal military government to charge you property taxes. And it's no different from a car. Okay, when you purchase a car, because there's no more gold backing of the money, because you're using monopoly money, there's no legal title to the asset that you're purchasing. All right, you only get equitable title to the car, which means you get use and possession of the car, but it's registered with the state. The state, because they have legal title, can tell you got to have it registered, got to have insurance, right? And you got to have plates on it. And so what happens if you don't do that? They come take your car. It even happened to David Strait. They took his truck, a year and a half ago or so. I think it was last spring. Took his car, they arrested him. And it wasn't that they were doing anything illegal. Okay, they have legal, it's the state's car. It wasn't his truck. Now you're going to say, oh, but I purchased it. I bought it. It's my personal property. No, it's not, because you bought it with monopoly money. Federal Reserve notes are debt notes. They're IOUs. You never paid for the truck or the house with money, lawful species of money. What you're using, what debt notes, what Federal Reserve notes are currency. Big difference between currency and money. If you buy it with money, which they won't allow you to do, you could obtain the legal title to your assets and you wouldn't have to pay property taxes or get your car registered. But that's not the way it is in today's world. So I'm telling you, get the car registered, get the plates, and get it insured. Otherwise, and I'm sure you've seen 100 videos on thing where they get stopped, they put their own plate on, they're just cracking down even harder. It's not your car. I'm sorry to be the one to tell you that. It's not yours. You purchased it with monopoly money. You don't deserve the legal title. It's not your property. It's not your house. You used monopoly money. You used an IOU. All you did was give them an IOU that somebody else would pay them. And again, all of this comes under trust law. Okay, this is what you've got to understand what's going on and why it isn't that they're breaking law. It isn't that they've conspired nationwide to take stuff from you. They have every legal right to do it and every right under the Constitution. It's just you don't understand what's going on. Okay, there's a way to do things correctly and there's a way to do them incorrectly. And if you do them incorrectly, there's going to be bad things that happen to you. And I'm sure people either know friends or have had stuff happen to them if they try these kind of things. Okay? I'm not taking the side of the government. I'm trying to tell you how things operate. I'm trying to explain the rules of the game. If you want to win the game, you better first learn the rules for the game if you want to beat them. It's very possible to beat them, but you got to know the rules for the game. All right? So they basically seized the real money. They give us their military script. Okay, which means we have to use their money to pay public debts. But the whole reason is because they're maintaining legal title to the assets when things are purchased so they can control everything. Now, if you want to know on a deeper level why, again, this is all done, is because they have the piece of paper that they own the car. They put those together in a batch of 10,000. So the state of Texas takes a batch of 10,000 titles that are worth $30,000 a piece to $3 million. They go to the bank. Okay, the bank holds those as collateral, and then they're allowed to lend out 10 to 30 times as much. So on all of those legal titles that the state of Texas are holding, it allows them to print credit to the state of Texas in order to pay their bills. So this is really how all governments are funded worldwide today, are holding legal titles as collateral and assets to the banking system. Okay, and if you want to fix things, fix the banking system. Get rid of the Federal Reserve. That would fix about 90% of the problems in the world. But it's the system that you have to understand is going on and how the government is being funded, how your legal title to all assets are being held by them, and how really you're really a renter of your house, you're renting your car, and a variety of other stuff. Okay? So let's give, the occupying force seizes all public property till the occupation is over. So if you read Proclamation 2040, it specifically tells you that this is full force and effect until a president comes along and rescinds it. And only a POTUS, only a president can rescind it. So again, if you are a Trump person, get him to rescind 2040, and guess what? We go back to a republic, and we'll go back to gold-backed currency. You'll go back to getting legal title to your house and car. You want to change things? That's how to change things. Okay, but if he's not going to do it, the only option is for you to do it as an individual. Okay, which is what I help people do on an individual basis, is to clear up that system. Okay. The occupying force sequesters for its own benefit all revenue of real property belonging to the hostile nation. The title to such real property is held in trust during military occupation until the occupation is complete. Again, I just kind of went over that. The commander-in-chief rules the country with supreme power, Article 2. This is why the gold fringe on the flag with an eagle on the top of the flag is in every courtroom. This is why that judge wouldn't remove the flag from the courtroom is that's where she is getting her powers. It's an Article 1 created courtroom, but is being run, administered by Article 2. There is no Article 3 in their courtrooms unless you know how to access that. I'm telling you, it's possible to access it, but if you don't know the rules of the game, you're sitting in an Article 1 court run by Article 2, which means they cannot see the Constitution whatsoever. All they can see is the straw man person or the surety for the straw man that's there and is acting as liability for it. Okay? For purposes of Social Security payroll and Medicare taxes, only residents of the state of the District of Columbia are liable. Every citizen of the United States is either an actual resident of District of Columbia or through residing elsewhere, like Texas, fraudulently construed to be a resident of the District of Columbia, which is the territorial sea, military jurisdiction, for legal purposes. Every time you claim to be a citizen of the United States on any government application, you're unwillingly giving them jurisdiction by voluntarily applying for benefits of a trust. Now, Randy will tell you that, I teach you how to sign any and all contracts which don't put you into their jurisdiction. Because according to trust law, they put your name in a trust. That's the straw man trust. And that's really who the liable party is for taxes, who is subject to code, statute, all of those kinds of things. So that's a trust. So in trust law, the person responsible normally for a trust is the trustee. He's the person that runs the trust. Now, you're not the trustee of the straw man trust. You are actually the beneficiary of the trust, but they always ask you to volunteer to be the trustee. They'll always put the piece of paper in front of you and say, will you please sign this? But when you sign that unrestricted, you're stating you're the trustee and you're handling it, which makes you liable. This is why you go to jail. This is why you have to pay the fine. This is why you end up paying income taxes, because you keep volunteering to be the surety. And look that word up. Surety means that you're a volunteer that is volunteering to take on the debt or obligation of another, which is your all caps name. Okay, that's what they put in trust. They can't put you in trust. That's against the 13th Amendment. They would all go to jail for treason tomorrow. Okay, so they developed this highly complex, complicated system where it's all about the name that's held in trust. Okay, but you have to understand what trust law is so you don't know how to sign as the beneficiary and not the trustee, which keeps you out of their jurisdiction. Okay, now let me read to you a Supreme Court case, which is the most cited case in our history. It's been cited probably almost 2,000 times at last count. This is what I consider probably, if not one of the most important Supreme Court rulings ever done. Okay, it was in 1906. It's called Hale versus Henkel. The court rules that there's a distinction between private natural persons and artificial persons. Do you think that's important? Absolutely. Okay. Here's a quote. Here's the quote I want you to hear. The right of the individuals are restricted only to the extent that they have been voluntarily surrendered, which means you give consent by the citizenship to the agencies of government. Let me repeat that. The rights of the individual, we're talking about your Bill of Rights, are restricted only to the extent that they have been voluntarily surrendered by the citizenship of the agencies of government. So what I'm telling you is no one can actually take your rights away from you. It's impossible. But you can waive your rights. You can volunteer and give them away, kind of, that kind of a thing. So don't get into this, they're taking them from you. No, you waive them in some way. They tricked you into waiving your rights, okay, which happens in court. Okay, if you go in court, just to touch on that just for a second, if you appear and don't disclaim that you're there on special ministerial visitation, if you appear as the defendant, you just waived your constitutional rights. If you hire an attorney, you've immediately waived your constitutional rights, because now you're saying you're too stupid to represent yourself, and now you need somebody to do it for you, so they're going to treat you as a ward of the state, that kind of thing. So there's many ways where they deceitfully trick you into volunteering. And you say that's bad, but I'm telling you, look at it the other way. look at the good side, that you have a choice. Okay, that now if you understand this game, that you've got to figure out how not to volunteer. Okay, because it's really you that's creating the mess here. Okay, they're like the devil, put the carrot out in front of you, but you're the dumb one taking it, thinking nothing bad will happen. You've got to figure out what happens and why the system is set up this way, and how can I maybe get something I want, but not waive my rights at the same time I'm doing it. Okay, let me try to give you another example. I think we got just a bit of time. I'm sure people have heard of Colin Kaepernick, the football player from the 49ers, who, did the kneeling and all that kind of stuff. Well, when you sign an NFL contract, and I've read an NFL contract because I have a nephew that plays professional football. So I've read those contracts, and they're contracts like any other corporate contract, that you are waiving your rights to certain things when you sign these work contracts. For instance, in an NFL contract, there's a thing about, your behavior, and that they can control or they can dictate your behavior in their area of employment, the football field. So they have I'll use the word control. They can tell the football players you can only act this way on the football field, and if you don't, there can be repercussions, and we can do certain things to you. Now, Colin Kaepernick seems to think that he had First Amendment rights, that he could do anything he wanted on the football field, only after he signed and waived all of those First Amendment rights away. Okay, so he doesn't know what he's talking about, and what happened? They got rid of him. Okay. And they had every right to, okay, because he waived his First Amendment rights when he signed that contract. He didn't stipulate in there that I wasn't going to adhere to those kind of things. Okay, he had a choice. Everybody always has a choice. Okay, they don't make you do anything. You're the one that is making the choices to go to the right or go to the left. Okay, that's what's really going on. Okay, so hopefully that's just a start to get you to understand of why things happen the way they happen. Things happen every day. And again, if anybody's got court cases in here, I think you'd be the first one to admit that they treat you like crap. They treat you as if you're guilty. They will not, under any circumstance, recognize common law. They will not recognize your constitutional rights whatsoever, because they don't exist in that courtroom. And until you learn how to make them, or to switch the mode, the jurisdiction of that court, or go to a different court where your constitutional rights are secured and can be recognized, that you're basically beating your head against the wall. Okay? And I think when I talked to Darren, he said some of the guys on this call might have some issues with the courts at this time. If you want maybe a little advice or help, I'd say email me. Even if you're at the stage of sentencing or whatever, there's always a way, believe it or not, to still get out of it. They give you 3 chances to basically say, I'm not the straw man, I am the real man. They actually give you 3 chances to say no. And most of the time, most people have got 1 or 2 strikes. And if you get 3 strikes, then you're going to jail. Okay? And I don't know the age of most of you guys, but there was a U.S. Supreme Court fella named Bork, who was supposedly one of the smartest judges in the country way back in the 80s. And he was going up to be a Supreme Court. And everyone thought he was a shoo-in. He was going to be the Chief Justice because how intelligent he was. And during the questioning, and I believe this still might be on YouTube, during the questioning, I think Senator Kennedy asked him something about jail. And he said, his remark was that everybody in jail volunteered to be in jail. And they were just couldn't believe what he said. And it went on, of course, every night, there was a bit about him saying this, and, everyone interpreted it as he was blaming the criminals and that kind of stuff. But he was actually telling you the truth. Okay? That you actually volunteered to go to jail. You had 3 chances to say no, and you didn't. So these are just examples. These are just examples of they put stuff in your face all the time. There was a guy named Nelson Rockefeller that was going to be the vice president of Gerald Ford when he got in 1976. Okay, this used to be on the internet. There was a Senate hearing, and they said, Mr. Rockefeller, how much money did you make last year? And he said, well, I think it was around $167 million. And then they said, well, how much taxes did you pay on that? And he said, zero. Next question. And they just went right by him. Nobody said a word. No one understood that all his earnings are in a trust. When they're in a trust, they're not taxable. Okay? So over and over again, I'm just trying to get you to understand trust law, which is really God's law. If you understand what's going on in the world today, it can be used for your benefit or it can be used for your detriment. And until you learn the rules of the game, some bad things can happen to you. And again, my thing and what I help people do is to try to teach them privately is how to stay out of that jurisdiction, how to stay in the private, how to create these trusts so you can accomplish all of the things that you want to accomplish. And I'll kind of leave it at that unless somebody has some questions, or I don't know how you guys run this. I appreciate the time. I hope that was informative to some extent, or whatever you guys think.
Yeah, trading. Is this on? Can you hear me?
Yeah.
Okay. Would you tell them something about the program that you make? I don't want to have you say anything that you don't want to have disclosed on YouTube, because that goes into your private, offering service. But would you describe in general what you do for the package?
Okay, so generally the outline and the most important thing is like this. Let's say, and think about this on a common sense, big picture level. If you want to prove to the government that you're not liable for taxes and that you have constitutional rights, don't you think it would behoove you to provide evidence to show them that instead of just saying it? Okay, so one of the first things we do is we do a declaration of status, but has 13 exhibits of evidence. Okay, so we provide like a Declaration of Independence, just like our founding fathers did. Then we provide, this all in affidavit form, then we provide 10 affidavits into why, we have these rights. Then we provide exhibits like the double authenticated certificate of live birth. Okay, you don't understand that they gave you the evidence you've needed all your life to prove who you really are in your proper citizenship status, your proper political citizenship status. Okay. There's a Supreme Court case, there's a 2008 Ortiz case that the U.S. Supreme Court is telling you that the difference between a Union States citizen and a U.S. citizen is political status. So again, I can name you 10 different cases and how they're telling you what's going on. And I know nobody reads U.S. Supreme Court cases but me, but boy, I'm telling you, they'll give you the answers if you just read the cases. So we gather evidence, get that evidence together, get it recorded, put it on the public record, and then what will we do? Well, don't you think that, they operate under the presumption of law, which means it really isn't true. They're just presuming that you've done all of these things. So after you get your political status changed legally in their system, which then allows you to claim exemption from income taxes. That's just one of the benefits. But then you have to notify them. We call it, equity is giving notice. Okay, Mr. IRS, Mr. State Department, Treasury Department, we need to send you a copy of what we've done. In other words, we come walking through the front door. None of this is behind, trying to sneak it in, come in through the back door. Don't tell them. That's one of the worst things you could do is don't tell them what's going on. You need to tell them what's going on, because legally in their system, when you give them an opportunity to respond to what you're doing, and if they don't respond, well, then they legally accept, because that's the very same policy and procedure they use on us, that if we don't respond to them, they assume it's correct. So you have to understand that you have to tell them what you're doing. You have to give them the legal opportunity to say, no, this is wrong. We can't, we're not going to accept this, whatever. Now, it's it's considered right if, here's the big if your affidavits are done correctly, which I can tell you if you've done David Strait and Anna stuff, those affidavits are not done correctly. That's why they don't accept them. You won't get something that says they're not going to accept it, but I'm telling you, there are flaws all over that paperwork and that they're not correct. So you have to be absolute 100% correct in your paperwork to get this stuff done. We create a trust, or I create it for you, okay, to use just like your straw man was being used to go into that jurisdiction. When you create an entity, all right, so the analogy is this, the game of Monopoly. All right, so when you normally play a game of Monopoly, you have to use their game piece. Now, you cannot play the game standing right at the table, but not use their game piece because they can't see you, right? So you, under their rules, normally you would use their game piece. When it lands on Park Place, you have to pay the rent. Now, the rules say, well, because they create an entity, the rules don't say you can't. So we create our own entity to play the game of Monopoly, but only that game piece is in a different jurisdiction than theirs. So when our game piece lands on Park Place or Boardwalk with a hotel on it, you're not liable. You're not susceptible to those codes and statutes. So again, this gets into the trust law, knowing that different trusts have different jurisdictions. Who creates those jurisdictions? Who has the control to control what law form you're using inside of that trust? These are all things you got to learn. So I'm sure most people have played the game Monopoly and understand that. So we play the game from a distance. We're just using an entity, a private trust, to do everything we need to have a bank account, to have car insurance, to buy a car, buy a house, do all of the stuff that is in their jurisdiction. But because we created that private trust, we now have said that federal government, state governments, if there's ever a question, you actually have to come into our jurisdiction, which is the Constitution and equity. You have to come into our jurisdiction for any controversies. So I don't know if you want to call it flip the script, but you're changing the jurisdiction and how things are operated. And that's the biggest factor, is you're going to make them come into your jurisdiction instead of right now, you're always having to go into their jurisdiction. Okay. And then once you get all that stuff done, you put your things in a trust. Again, let's just take an example. Once you create the private trust, you're going to put all your weapons in that private trust. ATF comes knocking at your door one day, says, hey, we know that all of these register or weapons have been registered. We want to look at them and make sure they're okay. And now you can say, I'm sorry, they don't belong to me. They belong to a private trust. And then they have to turn around and walk away because they know that any assets in a private trust they don't have jurisdiction over. But if you don't have that trust, they're going to assume that it's in your straw man's name, and that's what gives them the right to come take your weapons or to inspect them or do whatever they want. It's all a jurisdictional issue every time. Okay, and if you want out of their jurisdiction, you got to create your own jurisdiction and put your assets into that other jurisdiction. Does that help, Randy?
Randy, you can't hear you on YouTube. You gotta go up there to the mic.
Okay. Yeah, that's a pretty good overview. I'm got to turn on the microphone for these folks at the same time. Anyway, that's pretty good overview. We're going to turn it over and let people ask some questions for a few minutes, and I'll explain more after this. So we're not taking up so much of your time because I've learned so much from you. I'm still learning. Still learning how to sign everything because almost every document is signed differently. But anyway, so I'm going to hand it over to someone who wants to ask you a question now.
So the other day, our President Trump signed an executive order making the constitutional law the supreme law. I wonder how long would that take to trickle down into the judicial system?
It's the Supreme Court law now. Okay. Now, you don't understand that when you go to the Supreme Court, there's two different jurisdictions that the people, the plaintiffs, the parties are pleading. Okay. They're either pleading in the territorial military jurisdiction, or you have to plead that you want original jurisdiction, which is equity. Okay. And if the plaintiff or didn't ask for it, what do you think the default level of jurisdiction is? It's the territorial military. Okay. So you have to understand and know what you're doing. If you want original jurisdiction, you're the plaintiff. God damn it, you have to ask for it. It has to be on your pleading. That's Bates. Okay, Bates wrote a whole book on this. That the jurisdiction has to be on the face sheet of the pleading. And if it's not, you have waived it. You cannot ask for it later. Okay, so again, you got to know the rules to the game. All right, I'm telling you, you can go to the Supreme Court and get original jurisdiction if you know what you're doing. I know somebody that's done it. Okay, it can be done today. It doesn't have. We didn't have to wait for Trump to do it. It was done 5 years ago. Okay, I did a case. I sued the government in 1994. I got original land jurisdiction. I got equity. That was 30 years ago. Okay, I'm telling you, it's always been there. You just got to understand how to get there, how to ask for it, how to access the proper jurisdiction. Because there's two things going on at the same time, just like Matrix. Okay, and again, I do a whole podcast on jurisdiction, that you have these simultaneously democracy and republic that's going on right in front of you. The default level is the democracy, the military jurisdiction. It's already here. It never went anywhere. It's just hidden from you. Okay, and you don't know how to access it. This is what I'm trying to teach Randy and everybody else, is how to access that part of a different jurisdiction. Okay.
I have a question.
Now again, no, I'm sorry. Let me add one more thing. If Trump wanted to fix things overnight, all he's got to do is rescind 2040, and it would happen.
KL?
Yes.
I have a question, KL.
Microphone's on there.
Oh, I have a question, KL. You mentioned Phelps. Are y'all using his declaration of status?
Most of the time, but see, people are different. I'll give you an example. I've got, somebody's got maybe a wife that was naturalized. Okay, they come in under the 14th Section 1. They can't come in under Union State. I've got people that are born of a service member on a military base in Germany or Japan. They get a certificate of birth abroad. That comes in through the 14th Amendment. So you have to know how to construct the declaration according to what your circumstance is. Okay, so again, most people, if you're born in one of the 50 Union States, you were born on the land jurisdiction. That's why we get the double authenticated certificate of live birth as evidence of that. But we have other people that come in a different way. Many people have come in here from different countries. They went through the 5-7 year process of being naturalized. That is available to them. It's just got to be written differently than if you were here, because again, DC is not one of the Union States. And if DC was never one of the Union States, that means there had to be a different jurisdiction for them versus the jurisdiction for the 50 Union States. This is again why I'm telling you from the very beginning, there were two different jurisdictions going on. This is not something they really just created. It's always been there, always has been, always will be.
I've read some of Eric Phelps' writing.
Yes.
And that stuff's really good.
Yeah, that's very similar to mine. I learned underneath him also.
Yeah. Thank you.
You're welcome.
Next time, just ask him.
So KL,
Yes.
so who has the occupancy of the United States? If we're under military control,
Mhm.
who is that entity? What is that entity?
You mean the entity that is the United States, or who is running the United States of America? See, the Constitution is a trust. Okay, the 13 original states were the creator grantors. They hired a company at that time called the United States to run the United States of America. Okay, a company was the first one.
It was chartered in the city of London, right?
Right, which actually was a subcorporation of the Company of Virginia, which really, again, was a corporation of the Crown. Okay, so what you have, and throughout the years, those corporations or companies have gone bankrupt. Okay, when they go bankrupt, another corporation comes in to be the trustee, the federal government, who's running the show. Okay, so it's gone from a company called the United States to a corporation in 1873. That was what the Vatican started in Delaware. United States of America Incorporated. Then they went bankrupt in 33. Then it was called the all caps United States. They went bankrupt in 45. And now the present corporation that's running the United States of America is a corporation called the United Nations, which is a subcorporation of the IMF. Okay. So it's that kind of thing. The corporations are running the United States of America country. Okay. But as the states, as creator grantors, we have the power to fire them. Okay. We have that power. Okay. We can replace them for breach of trust. Or do you think they're doing whatever in our benefit? Absolutely not. Wouldn't you agree that we should be able to fire them? And that's the system that we were under. Now that trust.
That's right. We're the sovereigns.
Right.
We the people.
Right. We gave the power to our representatives to the states to hire a company to run the 19 enumerated powers. Okay. Again, that's a trust agreement. Okay. And the fact that I can prove that that's a trust again is to tell you that when the president is elected, it's not a popular vote. It's a state vote. It's a state election. Okay. Well, why is it a state election? Because the states were the original creator grantors of the 1789 Constitutional Trust. They're the ones in control. And they said we're going to do it by electoral college, not by the popular vote. And that, of course, that's the way it is today. All of these things usually can make perfect logical sense when you look at it from a trust structure kind of scenario. We have the power. We just got to fire them. We got to charge them. The easiest way to get rid of a government official is to charge them with breach of trust, because that can mean they can be gone. They can be unbonded. You can get a cop gone, a mayor, a representative. You charge them with breach of trust at federal district court level, they can be gone, poof, immediately. That's where the power is. Okay, it's in using trust law to enforce trust law. You can't go in there as a man. You got to say, I, John Doe, the beneficiary of the 1789 Constitutional Trust, hereby is charging so-and-so with breach of trust. That's when it'll stick. That's when it will work. Does that make sense?
Yes.
All right.
Hey,
I'm sorry. When you do your debt validations, someday try sending the CFO or COO or CEO that he's in breach of trust and see what happens.
that's a good point,
It'll be
Kale.
done today.
Because then he'll go, oh, Jesus Christ, I could lose my $1 million job. I better get rid of this one as fast as I can. Because they know that's the one thing where they can be replaced and be removed immediately.
That's good news.
Good point.
Good info.
Good point.
Yeah, I've been wanting to get you two together for quite a while, as we've both, we've talked about that. So, but anyway, we got a couple of other guys here that got some questions, and then Darren's telling me that we only got a few minutes.
All right.
Until we get.
Next guest is there, so.
Well, yeah, Ron, as long as you're okay with it cutting into your time. So we only got to learn a limited amount of time here at this restaurant. So
I got a question for you. I'm being drugged
Order
through
another
this.
dessert.
Yeah.
So I'm being drugged through the state court. How do I access this common law jurisdiction?
It depends if you've hired an attorney, depends on where you're at in the thing. Contact me by email. I'll give you my 2 emails. One of them is mrbeneficiary@gmail.com, and the other one is klfreedom748@gmail. Court cases, I have to know what's going on exactly where you're at in the system to know how to best help you. Okay.
Okay. Thank you.
and again, I'll fill these guys in, after we're done with this, in the basics. So
I got
one more question.
2 questions. One, you mentioned they give you 3 chances to get out. Can you
Yes.
explain exactly what those steps are, what points that we have access to those? And the other question is, you mentioned the 14th Amendment. Isn't that the one that's never been ratified by Congress?
That's not what the Supreme Court says. The Supreme Court acts as if it has. So you can provide that evidence all day long, but I'm telling the Supreme Court rules every day as if it was ratified.
Okay, the most important, I'm in a court case myself, and I'd like to find out what those 3 chances are for me to get out of their jurisdiction.
Here you go. Write it down. First strike is if you appear. And that whether you appear as the name, if they say, are you Mr. Johnson and you say yes, that's strike one. If you appear,
Okay, let me interject. Last time I was in court, when you called my name, I said, "I'm the living man. I am not the fictitious corporation before you." That was my response.
that doesn't work. You want to know why it doesn't work? Because they know you're a man. Okay, they're looking for the surety to the straw man. They're not looking for the straw man. They want the surety. They want the guy that's coming to be liable for him. They already know you're a man. There's no game going on as much as you think it is. Okay, so if you answer their questions, strike one. Okay, strike two. If you plead, did you plead?
No, I have not.
Well, good. Then you don't have strike two.
I
Strike
plead
three.
when they ask me to plead, I'm going to plead that I'm redeemed, that all my transgressions are forgiven and paid for by the blood of the Lamb on the cross of Calvary, against which there's no higher authority. That would be my plea.
All right. So far, then they probably don't have in personam jurisdiction. All right. Now they're not going to tell you that. They're not going to admit to that. They're going to act like they do. They're going to proceed as if they did. The third strike comes at the sentencing. Let's say they convict you, and again, you don't say that you object or you do not consent. And then the famous words are, "Do you have anything to say before I sentence you?" That's the third, I would say, attempt or the possibility to say something. So I have statements of elocution that you can use that could normally even wipe away even after you've been convicted. Because if you say nothing at the sentencing, now you have waived your three chances.
Yeah, well, yes. So if I just don't enter any plea, then at what point, what do I do then?
Normally, they're going to try to play it out, and at the last second, they're going to come to you and ask to you to plead because they know they can't convict you if you haven't pled. And you'll get the judge to say, "Well, I'm going to plead for you then." Well, they can't do that. They can say they're going to, but I'm telling you, they can't convict you if the judge pleads for you or
I was
pleads.
I was in a municipal court and I didn't enter a plea, and the judge says I'm entering a plea of not guilty, and then he passed me over to the prosecutor.
Objection, Your Honor. Objection. You're practicing law from the bench.
That's
You're
right.
not my attorney, and I don't accept your plea. I do not consent. I do not consent.
I do not consent. I do not consent 3 times.
That was a couple months ago. Can I retract that retroactively?
Write up an affidavit that on this court date, he said this, therefore I'm saying now for the record, because all affidavits are entered into the record. Okay. Put it on an affidavit, get it filed in the case.
All right, appreciate it.
Never, 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 ever. I'm Winston Churchill here. Never consent.
Correct. That's that's where you have the right to say I don't consent.
When you go to court, they're always making you an offer. And when you're silent, you're acquiescing and you're accepting their offer through your silence, tacit approval. So you always object and you always do not consent.
Right. If the prosecutor says something, I object, that's hearsay.
I've been sued 7 times since 2017, and I won every case.
You can
Judgment for the defendant.
Yeah, write up an affidavit of an amicus brief, which is friend of the court. Then you can just keep saying, "I'm sorry, Your Honor, is that a rebuttal of my affidavit?" Okay. Don't answer any questions other than, "I'm sorry, is that a rebuttal of my affidavit?"
I want to give an example here for everybody listening. Back in September of last year, I got pulled over, and I haven't had a driver's license since 2008, and haven't had any problem other than getting a ticket, and then it just goes away. Anyway, so I was coming into town, and I let off the gas just like everybody else, and a cop ends up pulling me over, and he comes up to my window, and I've rolled it down. And as he's walking up, he says, "I need to see your driver's license and registration." And I said, "Driver's license?" He says, "Yes, I need to see your driver's license and registration." I said, "Oh, I don't have one of those." And he says, "What?" And anyway, it just got funnier from there. And his sergeant was called out, and we went through this, and I explained the things to him, and they thanked me. The sergeant thanked me like 3 times for being so polite, explaining things. I said, "Yeah," and he says he's seen this stuff on YouTube and they're kind of belligerent. I said, "Yeah, that's not the right way to go about it. They don't train you guys in the Constitution. They don't let us know. We have to learn on our own. And I'm happy to teach you guys." So then, anyway, I said, "Look, you can write me a ticket. That's fine. I'll just go talk to the judge, which I've known her all my life. I'll just, tell her the laws, show her the laws, and it'll be fine."
And so when I did go to court, and I did not sign the ticket, they said they could take me to jail for that. I said, oh no, that would be a felony. So anyway, I didn't have to sign anything. And I went to court anyway, just to see if they put me on the docket. And they did. And they create bonds. That's how they're making their money. They're creating
Yes.
bonds and they're going after your SUAK. So if you don't show up or they find you guilty, whatever, they collect on the bond, right? Whether you pay or not. So that's how they're running their business, which justice is not supposed to be a business. That's how you know it's a corporation. So anyway, I go to court and it's not my friend. She's out of town. So it's a judge filling in for her. And he's not even there. He's on a friggin' TV screen. And I'm like, how can you have a court without the judge being actually in the court? Okay, but anyway, so I said, I just showed up a special appearance because I wanted to see if I was on the docket, and I am, and I shouldn't be because this court doesn't have jurisdiction. And he got very belligerent, and he threatened to throw me in jail 3 or 4 times if I did not enter a plea. And I said, you cannot compel me or coerce me into entering into a contract. At that point, he's saving face. He's acting still belligerent. And so he says, well, I'll just let the prosecutor deal with this. If you'll wait outside, then I'll have the clerk give you his contact info. Okay. At that point, I knew I won. So I go out in the hall and I wait. She calls me up. She says, well, the prosecutor won't be around for about a month. Might be longer than that, but he'll get a hold of you. I said, okay. I walked out of there knowing that was the end of it. To make sure, the next day I filed a open records request asking for his bonds and all kinds of stuff, and stuff that I've learned from Ron Adams here. A list that he's provided that's helped out, and so I asked for that, and guess what? They've never responded to it. I filed a complaint with the AG. He's never responded to it. So, but anyway, it's gone. I've never heard from them again. So that's my example of this, what we're talking about.
Let me make one comment about court. If they ever threaten you with contempt, they always threaten you first. They don't fine you. That's your opportunity. You immediately say, forgive me, Your Honor, I didn't mean to be contemptuous. That immediately clears the slate, which means they have to warn you again. Then you say it again. If they warn you again, you say it again. You'll never go to jail for contempt if you first say, forgive me, I didn't mean to be contemptuous. You have to clear the slate. You have to say something when you're supposed to say something. Okay? And let me say one other thing. 12 presumptions of Roman civil about how court is being going on. There's 12 presumptions. I'm going to read you 2 of them. Number 8, the presumption court of trustee. Presume you accept the office of trustee and government employee just by attending a Roman court. The presumption stands and it is assumed as one of the most significant reasons to claim jurisdiction simply because you appeared. Now, what they tell you also in this is unless you immediately rebut by saying I'm here on special appearance, ministerial appearance. So again, they give you the opportunity. Number 9, presumption of the government acting as a beneficiary. The judge acts in the capacity actually as administrator of the Cessna K Trust. He's looking for the trustee. He's looking for the beneficiary. Why? Because the trustee has to pay the beneficiary. That's how trusts work. So his job is to find out who's who. That's why he always says, are you Mr. Anderson? And if you say yes, what you're saying is I'm the trustee of the Mr. Anderson Trust. So what you've done by saying the word yes is you said, I'm guilty, the trust is guilty, and I'm going to pay. And the game is over with one word. Okay? So you have to claim the beneficiary position, which only leaves the prosecutor as the possible trustee, which means that's the guy that's got to pay. And all lawyers, in case you've never heard, have to bring their checkbook to court, just in case they do have to pay. Okay? The prosecutor acts in the capacity of the beneficiary of the trust. You act as the trustee because you appeared. The presumption stands and you are default the trustee unless you rebut the presumption. Okay? So they have court rules all under trust law. Again, I'm just trying to tell you, trust law is what's going on in the courtroom. Trust law is what's going on the roads. Trust law is what's going on with your driver's license, with your passport. It's all about trust law. Okay? All right, I'm done.
Okay, so we'll end it there. And like I said, I'll answer any questions these guys have after we're done on this, but I want to turn it over to Ron and let him do his part. And
Yeah,
I'd love for you to step in there, KL, and, you know, because I think you need to know more about Ron.
By the way, KL.
Oh, I thought KL's presentation was excellent, you know, little
KL.
Oh, he's
motivation
the
here for
master.
KL. Hell of a job.
He's the master.
But like I was telling Randy a couple years ago that, you know, I was sued for credit default on credit cards, you know, 7 different times since 2017. And when I went into court, it was a big education process for me because I knew nothing about it. And after the second or third case, I figured out how to win the cases. The first thing I did, along with the trust matters, was to submit a declaration of expression of the trust where I told the court that I was the beneficiary and not the trustee and not the surety. And I filed a Form 56 appointing the clerk of the court as the fiduciary of the trust. So that leveled the playing field.
You rebutted their presumption.
Exactly. Before I even
And you grabbed the beneficiary position, which means you can't be the liable person.
Yeah,
Because
and
they didn't
that's how I
object.
won every case.
They didn't object to the fact
was
that you were
7
the
of them.
beneficiary.
There was 7 of them. So, you know, the declaration of expression of the trust is the way to go.
Yes,
And
because if
with
they
the
see
Form
the
56
trust, if they see the trust, then the laws of equity apply, not statutory. Okay, now they can see you as a constitutionally protected man. You see,
Right.
you get your rights.
Yeah. So, you know,
exoneration.
$125,000 worth of credit card debt went poof.
Poof.
That was my court experience, and the other way to deal with the court, when they call your name, you can collapse the SETI KV or the constructive trust by expressing in words that you're not the surety, you're not the trustee, you're the live flesh and blood sentient creative man. You're not the all cap corporate fiction inscribed on the complaint, that you're the executor of your estate and the beneficiary of the trust. I do not consent to contract nor joinder, and I waive all benefits of your offer. That'll end it right then and there.
Right, because when you hold up, if you had the birth certificate in your hand, especially a double authenticated, you're the beneficiary. That's the evidence. So, Your Honor, if you think I'm the trustee, then by the laws of suretyship, I'm merging the titles and collapsing the trust, which means the court case goes poof. By combining the titles, there is no more case.
Now, one other individual asked, well, how do you enter into common law in a regular court, you know, which is typically admiralty or maritime. And the way you do that, since 1938, all courts are controlled by merchants or bankers law. And that's the UCC, the Uniform Commercial Code. And the one escape hatch that they put in the UCC for us, we the people, is UCC Article 1, Section 308, without prejudice. By exclaiming your reservation of your rights under that UCC law, you're putting yourself in common law and you're standing on the land. And all courts have 2 jurisdictions, one for criminal and one for civil. So you would immediately ask the court, is this a criminal matter, or is it, you know, first of all, are we on the record? The judge will say, yeah, or magistrate will say, yeah, we're on the record. And then you'll ask, is this a criminal matter or a civil matter? Now, if he says, well, it's a civil matter, that means there's a contract that has been breached. So once you've reserved your rights under UCC Article 1, Section 308 without prejudice, you immediately ask to see the international contract that you're obligated to perform under. The courts cannot do it because the international contract that you're obligated to perform under is the national debt. All the courts are owned by the British Royal Crown Bank Corporation. And their only purpose is to extract wealth out of the American people the taxpayer, and satisfy the national debt. So once you ask for that international contract, you're obligated to perform under, they'll usually shut down the case right then and there because they can't admit.
Can't bring it forward. There's no contract they can bring forward.
Right. So if there's no contract, there's no case. Now, if it's
No contract, there's no compel for me to perform. That's the point, right?
yeah, exactly. And now if the judge says, or the magistrate says, well, it's a criminal matter, you know, it's a speeding ticket. Well, that's simple. Then you ask to, for them to point out the aggrieved or damaged party in the courtroom, because there has to be an aggrieved or damaged party that's either sustained bodily injury or had property damage. And if they
And
can't
that's
point that
corpus
individual
delicti.
out, what's that?
That's called corpus delicti.
Yeah, corpus. So if they can't identify the injured party, there's no crime. There's no crime. So just like the civil matter, there's no contract, there's no case.
So again, you're rebutting their presumptions.
Yeah.
But you have to verbally state it. That's the point.
It has
Let-
to come
let
out
me
of your
tell-
mouth.
let me
It
tell
has to
another-
come out of your mouth and get on the record.
That's right.
Let me point out another thing though, and we know that these judges don't ever listen to us, but I was fighting a traffic ticket in this area where we are now. It's like 30 miles away, but anyway, several years ago. And I was questioning the cop and he failed all over the place. And I asked him if he could prove corpus delicti. And the prosecutor came out of her seat and so did the judge. And he says, we are not entertaining corpus delicti here. I said, well, if you're not going to entertain it, then you have no jurisdiction by your own admission. Well, they found me guilty anyway because they're kangaroo court. But I've never paid on it. And they haven't ever collected either. But go ahead, Ron. Sorry about that.
Yeah, and so that was pretty much my court experience. The other issue that I was successful on was discharging debt. I had a daughter who was going through bachelor's, university at the University of Vermont. Got her through the first 2 years of her college education, and then I ran out of money because son number one went through and took all my money. So I wanted to get the daughter through. So they had a agency there that would lend money, for the college education. And
Credit.
I signed a promissory note.
Yep.
It was north of $100,000 to get her through the last 2 years.
Mhm.
And after I was paying about 5 or 6 years on that, $1,000 a month, I realized, I'm not going to have any retirement here unless I do something about this. So what I did was I wrote a certified promissory note in the amount of the outstanding balance, and I submitted it with 21 Susan B. Anthony dollar coins, which is constitutional money. Some people will use $21 U.S. Postal Service money order, but it's constitutional money. And I tendered it to the agency, and they accepted it. They never returned it. They had 72 hours to return the instrument, outlining the defects of the instrument and why they're returning it. They didn't do that, so they accepted it. They agreed to it. Silence is tacit approval. And eventually, the paperwork got sent to the Department of Education, and they came after me for the amount of money. It was about $75,000 at the time. And I went through the rigmarole with them, and eventually they said, okay, the debt's discharged, fell off my credit report, and it's gone.
Mhm. A tender is discharge. UCC
So that would be
3-603,
UCC Article 3, Section 603, tender of payment.
refusal is discharge.
And that's right. And as KL said, paragraph B, refusal is discharge.
I know it by heart.
Paragraph B, right, KL?
That's right. You are absolutely right. Especially if they don't give it back. That
Yeah,
means they,
so
they
not
put
only,
it on, they put it on Wall Street and they made money. So everybody's happy.
Yeah, there's no damaged party. Who's the aggrieved party here?
Yep.
So, yeah, I mean, so that's pretty much my story. and I work with folks to get them out of credit card debt. And,
Sounds like you know what you're doing.
Okay,
it's my
so
firsthand experience, firsthand knowledge.
Ron, can you tell the group about what you offer? Because and give them your background about being a forensic CPA and who you've worked for and all that.
Yeah, I'm a certified public accountant, and I'm certified in financial forensics, and I do fraud investigations. And I also prepare forensic property and mortgage loan audit reports in foreclosure litigation. And I'm brought in as an expert to testify and explain that the plaintiff on the complaint is fake, number one. It's typically a shill entity. The real party that's bringing the suit is probably Fannie Mae or Freddie Mac or maybe Ginnie Mae. And there's a way to prove that. So when they come into court and they're saying we represent XYZ Trust and they're the trustee, we shoot that right out of the water right away. And so they're coming in with a complaint with a fake, false plaintiff.
Yeah.
And then the other thing is the lawyer, a lawyer allegedly representing the plaintiff, has no contract with them and no authority. And they're not registered under the Foreign Agents Registration Act, which is 22 USC Section 611. They have to be registered as a foreign agent, and they're not. So you can challenge their authority to even be in the courtroom. I've said to the judge, Your Honor, who is the stranger in the courtroom? Remove them.
You got to request evidence that they can legally act on the creditor's behalf. Show me the contract that allows you to be here, be their agent. Yeah.
Show me the retainer contract you have with your client. They can never produce it.
Right. Another couple of
presumptions. One of the presumptions KL said you have to blow out of the water.
You always have to rebut their presumptions, because that's the opportunity every day, is to keep rebutting what they're even standing there for.
Let me kind of add to that. There's my brother-in-law is actually going through Ron's process too. He's already gone through KL's process. Packet of it yesterday, which I have just breezed through real quick, but there's all kinds of stuff in there that expose the fraud by the mortgage entity. And the first point, which I've been saying for a long time, is when your mortgage is sold to one of these investor entities or servicers, they have dissolved the promissory note. And by dissolving that promissory note, it is now, there's no chain of title between that and the deed of trust. What they're doing is they are actually using that to securitize your mortgage. And basically, it's like the best example I've heard or reference is you take a carrot and you turn it into juice. You can never turn it back into the carrot again. So that promissory note is gone. When they bought that note, your note was paid off. And you can say simply, thank you very much. I appreciate that. And then give them notice that their contract is now terminated and your mortgage is wiped out. Somebody came and paid it, but then they are selling it repeatedly. And the example I use on this is as a graphics designer and special effects tech and movies and all that, I know a lot about copyright law. And so when you have a photograph, say you've taken this beautiful picture and you get an agent and you want them to distribute it and make you money. Okay, so agent agrees to do that. They go out and license it to several magazines and you start getting paychecks. What you didn't know is that they went across the pond or to England or something and put it in magazines over there, and they thought, you'll never know about it, so they pocket all the money. This is the same thing that's happening with the securitization. They're making a ton of money on it and not telling you about it, and they never got your permission to use your promissory note and your property as the equity or the instrument to do that. So I just wanted to point that out. Do you guys agree with me?
Well, yeah, you're the beneficiary of the mortgage. You're the beneficiary of the loan. Okay, and Ron would tell you that if they ever really did produce the full accounting, which means the credit and the debt side, it would prove that you don't owe any money, that there's actually money owed to you.
Correct. And that happens with every kind of loan. If the bank is
Everything.
big enough, they securitize them all. And when they securitize it, it's done.
Right, but see, again, you got to know trust law to understand your rights as the beneficiary to come in and ask for exoneration or subrogation of that account, so you can be entitled to the collateral securities or exoneration of the debt that comes from being the beneficiary in a trust. And again, Ron would tell you, you got to get the judge to see the trust, right, or acknowledge it or see that it's there.
Ron?
Yeah, the true debt in these litigations is the unpaid loan account on the books and records of the true creditor, like a loan receivable,
Yeah.
or an account like that. They can never produce that. That is the debt. That's the debt that if it's not paid, they write it off, take a loss, and get a tax benefit. So there is an aggrieved party there. But the people in the courtroom do not have that loan account on their books and records, so there's no debt. While the mortgage and the deed of trust are evidence of a debt, it's not the debt. The debt is the loan account on the books and records and general ledger of the true creditor. And the true creditor is never in the courtroom, and you have to attack that.
That's correct.
Okay, so Ron, you want to explain to these guys what you do, what your service is, other than just generally, tell them about your website, I guess, so you can, define your 3 levels of what you do.
Yeah, I mean, essentially, like I'm a forensic accountant. I testify in court, and I spend half my time in litigation support, working with typically plaintiffs. I've got a website called debtremediationtools.org/register to see the video. It's www.debtremediationtools.org/register or www.debtremediationtools.org/go. And I have 3 levels of service. First level of service is you can download the 4 debt validation letters to produce your administrative process to challenge the debt, and then go for a declaratory judgment once you have all that information in court. And number 2 is you get the same 4 debt validation letters, but then you get my coaching service to help you through that process. And level 3 is where I do it all for you. And I also do forensic mortgage and loan audit reports to submit in court. That's essentially the services I provide. And most of my customers are credit card people that are being sued by debt collectors attempting to collect the debt, people in foreclosure, or maybe marital dissolution, and they need an expert witness to testify on the value of any marital assets, for example, a small business or whatever.
And Ron would tell you that when these debt collectors, third party that have bought the debt from somebody off, that they will walk in and won't notify you, and they try to get summary judgment on you. This is why you got an answer. You have to answer.
Yep.
All you got to do is rebut, but you got to answer. And if you
That's
don't,
right.
they're going to come in and whack you.
Yeah, the lawyers typically like to go to a summary judgment hearing as fast as possible to sort of knock you out of the box. But the way you oppose that motion for summary judgment is to inform the court that there are material facts that continue to be in dispute and need to be litigated. But that has to come back with a formal motion opposing the motion for summary judgment.
Which means you got to answer or countersue.
Yeah.
In the answer, yes.
Yeah, and typically the answer includes there's an unpaid loan account. There's no unpaid loan account on the books and records of the creditor. We've asked for it. They never presented it. The attorney here does not have authority to be here. He has no retainer agreement. He's not registered as a foreign agent under the Foreign Agents Registration Act. And there's a whole laundry list of bullet points that we put in the
most important
motion for summary judgment.
The most important part I'd like to add to yours, Ron, is that an attorney cannot represent or speak for the witnesses of the complainant. So if you got like Bank of America that you're going up against, you can object to the attorney speaking on their behalf because he's not allowed to.
Yeah, he has no firsthand knowledge of any of the facts. So he can make bold, naked allegations that might be interesting to the court, but they're not sufficient for a motion for summary judgment. And there's a case called Trinzi versus Pagliaro, which outlines why that's the case. It's a Pennsylvania case, I think in 1966. And we always include that in our motion objecting to the motion for
Yes.
summary judgment.
Counsel cannot be counsel and witness at the same time. That's what that said. So whatever he says is not firsthand perfected, not admissible. But you got to object. You got to say something. It's the same thing again. Yes.
And KL, your program, when you've gone through it like I have, you have made it clear that we are only to be either sued or sue in federal Article 3 courts jurisdiction.
That's only where you're going to get your constitutional rights. If you really want to do that, if that's a part of the case that they violated your constitutionally secured rights, then you have to go to an Article 3 federal district circuit court. Yes, but you can fight and defend the case as the grantor beneficiary of the court case, or the credit card case, or the mortgage case, because you can appear because you have a beneficial interest. So you can appear as a third party by not admitting that you're the trustee defendant. So there's still a way. It depends on what you want to accomplish. Again, every case is different.
And that would apply to when you go through your program, what we do, and same thing with Ron, his help is we create a copyright of that all caps name but KL through your system, it's separating us from that and creating the private trust.
When you claim it as your property. That's just like a copyright. That isn't in a copyright. You're claiming that's your total property. So you have to, first of all, you have to prove why it is your property. Once you claim it, then you convey it into the private trust, and that's how you control it.
Yeah, and part of that is in your process is notifying them that they are terminated as our guardians, and therefore we then claim it back into our private trust. Right. And at that point, they can't do anything.
Well, you have to claim the titles. You have to claim the equitable and legal title to the name.
Right. So the copyright violations after that would be reason to remove it to federal court if you wanted to go that route, right?
I would go to federal court if I'm the plaintiff. If you had to be the defendant, you might have to stay where you're at. So it depends on what, again, you're doing with the case. If you're coming as plaintiff or you're just defending a case.
Okay. Anybody else got any questions?
Yeah, Randy.
Yes, sir.
How do I get KL's contact information?
I'll send it to you. And I was going to announce also that I'll let all these guys have your contact information for both of you, so they can contact you directly.
Great.
Yeah, we got another question here.
So under the mortgages and all that, is that where they're tied to a holding company? Because of the security that's bonded. My understanding is bonds are taken to a holding company through 31 CFR 233.17. From my understanding, you could be a if you tie your trust to the 233.17 as a holding company, you can become a government contractor. And you're able to get ask for full disclosure FOIA from the SEC on all bonds created in your all caps name. 31 CFR 233.16, the principal in that is us. So my other question is are they taking property, which is a household good, and making it commercial.
Did you hear all that, Ron?
I'm not familiar with those laws. I'd have to research those statutes. I just don't have a good answer for that because I would need to do some research.
He said, okay, he walked away from the mic. So, okay, anybody else?
Got one.
Okay, Darren's got one.
We have a lady that got life in prison. I was helping her with. It was over laundering money is what they did the case under. And we're trying to get her back out now. And we were told if we get the birth certificate authenticated.
It already is.
Okay, it already is. That we can do a notice and notify the court that, you know, for example, I'm her power of attorney, notify that there's been fraud upon the court and get her released. Now, I know a little bit about because I talked to the gentleman that's working on it, but Ned may have more. Could you have more details on that?
Well, yeah, the judge, she didn't want to enter in a plea. The judge said she was going to enter into a plea. And then I think she acquiesced because she was forced into a plea.
She never answered for the plea.
Oh, she never answered a plea. That's correct. And she has the judge and prosecutor got in trouble, so they're retrying the case this Monday, April 22nd. And they tried to give her life for crimes that didn't warrant a life imprisonment. And it showed that the judge and prosecutor were biased and possibly working together in the case.
I think that's
So
more
she-
of a KL question.
Yeah, she actually asked for common law court several times, trial by jury. She called out a star courtroom on the judge, where actually judges came out of the back room, which was an actual star courtroom. And
There was also no true bill on the indictment, and we had 4 different witnesses. Every day we would have multiple affidavits of everything the court did that was wrong. And we, you know, basically cited everything that went wrong throughout the full duration of the trial.
I think that's the breach of the trust topic that KL's talked about.
yeah, they have, she had several properties that they locked up, and there's a lot of discrepancies where, you know, even the prosecutor possibly broke the RICO Act. So they just kept rolling like everything was good.
But the question is, do you have any knowledge of getting which we have, the birth certificate, it's authenticated, and having some type of document that could be drawn up to notify the court that she needs to be removed immediately from prison?
Okay, 1 second. What about putting her in as?
Does she have a spouse?
No,
Okay,
What about
mother?
her in property
what's
and
that?
then claiming her? as part
Let
of-
him answer this first, Joe, or do that next.
Okay, go ahead, KL.
Well, an old time way to do that was to do a writ of habeas corpus by the spouse or the mother or father type of thing. Because a
That's not
habeas corpus is an Article 3 writ.
I've done about 8 of those, and I don't have any luck with habeas anymore.
So the other question that I don't know is what she was charged with. You understand that if you're charged with harming a person or property, they can pull you into their jurisdiction. That just like the Constitution says so. So
Money
it
laundering.
depends on the
and-
charge.
Money laundering across state line and
All right, so
also,
that's not, there's no
You know-
injured party there.
Also, KL, in Tarrant County, they have a special task force for elder abuse. And that's their main mission, is to try to, you know, protect the elder people in the county.
yeah, they got her.
Well, that might be the tough one. See, again, they're alleging harm to some person. Okay,
300.
yeah. as far as the birth certificate that we talked about early, that you would want to, at least what I would try is to get a copy of that. And that if, the court's assumption that I'm the trustee, I therefore merge the titles and extinguish the trust. Email me and I'll give you a thing on merging of titles.
Speak up, please.
What'd you have?
Come on up here, Jason.
Yeah, thank you.
I've heard part of this is like making her, I don't know if you ever heard of this tale, but like making her trust property, then you're talking about trust and then just going and claiming your property and getting her out of jail that way.
But see, you can't claim a person as property. You can claim the name as property. Okay, that's what you should, that's how you should always get your kid back. Is you're not in there to get your kid, you're in there to get your property. That name that child has is your property. Why? Because you, as the parent, granted it to them. You have the highest claim by nature to that property, the name. So it's always about the name game. It isn't about the person. It's the name. It's the property. Not the person is not the property. The name is.
And the person's the surety at this
Yes.
point.
Person's always the surety. They know you're a real man or woman. By your actions, are you acting like surety? Okay. If you make a motion and you write a motion that says motion, you're acting as the defendant. That's just another key. Don't ever write the word motion, write the word writ. Common law is writ. I'm making a writ of whatever. Okay.
Yeah, if you issue a motion, because a lot of people that are just getting into this, I say, well, what kind of motion can I write? I say, you don't ever write a motion. That's subjecting yourself to their jurisdiction.
Only
Also-
plaintiffs and defendants write motions. Okay.
Also, I was also told that you want to do it handwritten and in pencil on your writs.
Well, you don't have to, but it helps because the handwriting is more powerful than typed. That shows you that you have the higher authority. Okay, I usually do that on appeals, or if you're going at a high level, then I get into the handwritten or in cursive. In other words, I'd do it in cursive. I wouldn't even print it because then you're for sure proving who you are. Okay.
Okay, any other questions? Nope, nobody else? Okay.
You mentioned that you can go straight to the U.S. Supreme Court on a habeas. Do you think that'd be more effective doing the original jurisdiction to the U.S. Supreme Court as opposed to going, say, district? See,
Well,
right
you
now,
got to go to the district. You got to go to the district or circuit first with a writ of habeas corpus. You can't. I've never seen anybody go to straight to the Supreme Court with a writ of habeas.
okay, so you go to district, then you go to the Texas Court of Criminal Appeals, and
Yeah.
then the U.S. Supreme Court.
Right. Why do you go there? Because the district judge can act as a chancery judge. And for sure at the circuit level they can. That's where they can see your constitutional rights. Okay, because there's an Article 3 judge looking at that paperwork, which in a writ of habeas means you either produce the person or you better be standing in front of me, a moving party, telling me what's going on and why they're in jail. That's a 72-hour limit that they have to appear in front of that judge and to explain themselves.
But only once you've made the writ
Right.
for
see,
habeas.
Right.
Right. We had a situation, I won't tell you the county, but we did a habeas, and the DA actually looked it over first and put denied, and then he mailed it to the Texas Court of Criminal Appeals.
You have to. Yeah.
They can actually make comments on it, the DA, that the county where they got convicted.
Well, you got to understand in court, you got to give them an opportunity to respond to what you're doing, and vice versa. When they put motions in, they have to give you a 2-week notice. You have to give them notice that you filed something. It's they call that what's fair. That's the equity part of the court. So if the opposing or moving party can put in a response, that's fine. There's nothing wrong with that.
Okay.
You just want to get it to the right judge. You want to get it to the right court so they can see what's going on. where, again, constitutional rights can be seen.
Okay. Anybody else? Okay, well, guys, right, okay, Jason's got one. Come on up. You gotta be up next to this mic.
Do you help people, that might want to submit a declaration of status?
That's what he does. That's what KL does.
Okay, okay.
That's his whole program, pretty much.
All right.
Because here's
So I
why.
will show, Kale, I brought my documents and I was gonna show it to these guys if they want to see them to get an idea of what you do. So
Yeah.
I'll show Jason that when we're done.
All right, so let me explain why you have to do the declaration of status. You have to provide evidence you're a private person. U.S. citizens cannot get equity, cannot ask for their only a private citizen can. So don't you think it would be important to have evidence of that private citizenship status in order to get access to, so you can be seen in that court? Because the presumption is you're a U.S. citizen until proven otherwise.
As in the corporate citizen.
Yes, and the corporate citizen, that you're surety for it. Yes.
Yeah. Okay, so Ken?
Going through a state court and they're violating my constitutional rights all over the place. How would I go about doing a breach of trust for that?
Wait for the court case to be over and do a pleading as the plaintiff, federal district court. Isn't that where they take even civil rights violation? You got to go to federal civil court. You can't do it in their court. You got to go above them.
Yeah, because they can't see it.
Correct. You got to go to the right place. And the only other ticket to get in there is that you were denied your adequate remedy at law, is the phrase. The reason I'm here, Your Honor, is because I was denied, I was found guilty, I was denied my adequate remedy at law. That's the ticket to actually that they might see it, other than providing evidence that you're a private citizen. Those are usually the two requirements, tickets, I call them tickets to get through the gate.
Okay.
So does doing the declaration of status also knock out terms in the IRS, not just U.S. citizen, but U.S. national and the individual as sole proprietor?
Oh, yeah, it does all of that, but don't ever use that term U.S. national or American national. That is, when you use that term, you immediately put yourself under the military territorial jurisdiction.
What about non-citizen? Oh, sorry, go ahead. Sorry.
Those are terms under their statutes and codes. Don't use them as your authority by claiming that's who you are, because that's what you're doing. You're immediately saying I'm under their territory jurisdiction. You're a Union State citizen. You're not an American or not a state national. You're not whatever Anna and David say. That has immediately got you into their jurisdiction.
Non-citizen national?
That's right. Just
Okay. Okay.
Okay, Kale, do you want to tell them about whatever website or?
I don't have a website. I act in the private. I'm not public.
Okay. You have a bunch of videos, but that's a link. I
So
know
just
that.
ask me for the videos. I've got at least a dozen videos through
Okay.
Rice TV. All you got to do is email me and I'll send you the link where all of the videos are. And that's what the first place I would tell you to do is watch the videos. Watch the video on jurisdiction. Watch the video on the birth certificate. Watch it on the martial law. Watch it on the myriad Supreme Court cases that I go over. All of that stuff is relevant, and it's way too lengthy to try to get into the time frame here.
No, I know. I was just wanting to offer these guys. So I'll give them your email addresses and so they can request that. Darren, yes.
Can
All right.
he come join us again? Because this is very.
Okay.
And just see when he's available again.
Okay. Darren's asking me to ask both of you guys if you would be willing to come to other calls like this at other times, because they recognize the value of what you guys are offering.
Yeah, I would, and try to figure out what you want me to talk about.
Okay.
I'll explain everything that's going on. You just let me know what you want to know, what you want to hear.
Okay. FYI, Kale, I sent you an email this morning, very early this morning. And when I get home, I was hoping that you'd have an answer for it. I know you're busy and you got everybody else to deal with today, but I was going to file those documents today, and I wanted to make sure that I was doing it right.
I will look at that as we hang up. How's that?
That sounds great. Okay, guys, I appreciate y'all coming on this.
I appreciate it.
Yeah, Ron, get a hold of me. I got a couple questions for you too.
I've been wanting to get you guys together.
Well,
So, okay.
Ron could help me because I do kind of the stuff he does, but it takes too much of my time. I'd be more than happy to refer him over. That's the whole
Well,
point.
and like I've told both of you guys, y'all would complement each other. And, the way I see it is we're all in this together and we need to, share the burdens and share the information and help each other. There's too much work for any one person to do.
Right.
So,
That's why I
There's
could
a
send
lot
it to
of
Ron.
need out there in the community.
Absolutely.
There is a lot.
The market demand is extremely high. Wouldn't you say, Ron?
It's just like a tsunami.
It's an infinite amount right now. It's just it's
Exactly.
never
It's
ending.
getting more and the wave's getting higher and higher every day.
Right.
Yeah. Okay, guys, thank you. And I'll be talking to both of you real soon.
All right. Thanks. Bye.
Bye.
Great job, KL. Great job.
Oh, thanks, Ron. You too. And again, you can spend more time with them than me. I'd be more than happy to let you take that kind of stuff from me. Thanks.
Back at you.
All right, see you guys later.
Right there, stay on for a minute.
Okay. They're saying that there's one more speaker here that's coming on, and y'all are welcome to stay for that if you want. I don't know anything about it.